Hello, and welcome to Your Election Questions Answered, a Q&A session with Campaign Legal Center. I'm Manal Haddad, Senior Communications Manager at Campaign Legal Center. Thank you for joining us. Campaign Legal Center is a nonpartisan legal organization dedicated to solving the wide range of challenges facing American democracy. We fight for every American's freedom to vote and participate meaningfully in the democratic process, particularly for Americans who have faced political barriers because of race, ethnicity, or economic status. Our work is especially relevant at this moment. The 2024 election is underway, and Campaign Legal Center is fighting back against unfair voter purges, ensuring voters' right to know who is spending to influence their vote, and guiding states through the election certification process. We know there are many questions surrounding this election, and that's why CLC is excited today to kick off the first in a series of Q&As with a rotating panel of CLC's election experts. We received an impressive collection of questions in advance of today's discussion, covering everything from the electoral process to campaign finance laws, and we're thrilled to have our experts field a number of them today. Thank you to everyone who submitted questions, and for those of you interested in continuing the conversation, we'll be hosting our next Q&A session on October 29th. So keep an eye out for the invitation in your email and a chance to ask your questions. If we are not able to answer your question today and you are a member of the press, please email your question to media@campaignlegal.org. If you are a member of the public and we are not able to answer your question today, please join us for our next Q&A event. Now, I would like to introduce today's panel. Trevor Potter is CLC's president and founder, leading our efforts to advance democracy through law. A Republican former chairman of the Federal Election Commission, Trevor was general counsel to John McCain's 2000 and 2008 presidential campaigns and an advisor to the drafters of the McCain-Feingold campaign finance law. He's worked at the intersection of money, law, and politics for decades, leveraging his expertise by teaching campaign finance law, testifying before Congress on federal election proposals, and during the 2020 election season, being named to the cross-partisan National Task Force on election crises. I also want to introduce you to Erin Klopak, who's our Senior Director of Campaign Finance at CLC. She leads our work to promote and defend strong campaign finance laws and ensure that existing laws are enforced. Before joining CLC, Erin spent nearly a decade working on campaign finance issues and the Federal Election Commission's Office of General Counsel, including as an attorney and then assistant general counsel in the FEC's litigation division. Danielle Lang is Senior Director of Voting Rights at CLC, where she leads CLC's efforts to safeguard the freedom to vote. She litigates in state and federal courts from trial to Supreme Court and advocates for equitable and meaningful voter access at all levels of government. Before leading several of CLC's successful cases to protect voting rights, she represented low-wage immigrant workers in wage and hour discrimination and human trafficking matters. Jonathan Diaz is Director of Voting Advocacy and Partnerships, where he helps lead CLC's work on combating election manipulation and coordinates with CLC's work with partner organizations at the national, state, and local levels. Jonathan has also litigated voting rights cases across the United States and frequently appears as an election and voting rights expert across the media, including as an election law analyst for CNN during the 2020 election cycle. Jonathan and Danielle also co-teach the election law practicum at Georgetown University Law Center. Thank you to the members of the panel for joining us today and answering what I'm sure are questions that are on the top of the minds of many voters today, going all the way through Election Day. Let's jump right in. We'll start with Trevor, if you wouldn't mind taking this first question, which is, what happens if a candidate doesn't accept the results of their election?
Thanks, Manal. It's great to be here today. I think it's important to remember that when we talk about a presidential election, we have 50 elections in the 50 states and the District of Columbia. And so when a candidate questions an election result, they're questioning something that happened in a specific state. There is a process for doing that. It is entirely appropriate for a candidate to say, this is really close. I'm within the range where I should have a recount, or I think there was a problem in this area that needs to be reviewed and adjudicated. a machine froze, ballots were lost, whatever the issues are, state law has a way of reviewing those and reaching a result. So your question really, I think, is what happens after that process when questions have been raised and they've been answered by the state through its electoral review. At that stage, traditionally in this country, we've recognized that the election is the voter's choice, that at the end of the day, the voters have made a decision. It's been reviewed to make sure we know what that decision was, and then we accept it and move on. I mean, the most recent example of that was not that long ago in the 2000 election when Vice President Gore and Governor Bush were arguing over Florida. And they had exactly this. They had a recount process. That case, of course, ended up in the Supreme Court, and the Supreme Court said, we're going to stop the recount, and here's the result. And Al Gore, the Vice President of the United States, the Democratic nominee, went out and said, I disagree with the result the court reached, but they have spoken. And we have a new president, and I will support him and work with him. So that is the tradition we've had until famously 2020, when the incumbent president continued to say he disagreed with the results after the votes had been certified and even after Congress had accepted them. So I think for a basic understanding of democracy, we have to accept that the voters get to make the choice, not the politicians. And once the voters have demonstrably made that choice, we should be accepting it and recognizing those results.
Thank you, Trevor. And speaking of recognizing those results, our next question is that we have seen attempts by bad actors to try to delay or halt the certification of election results. In a recent example, the Georgia State Election Board passed new rules requiring costly and time-consuming hand counts. And I know there was a decision in that recently as well. Maybe starting with Jonathan, can you tell me a little bit about why hand counts are a bad idea? Let's start there.
Sure. So hand counting is a concept that has gotten a lot of traction over the last several months and years as folks who have doubts about the security or the accuracy of our election process have started pushing jurisdictions to abandon machine-assisted tabulation of ballots in favor of hand counting. There are a few problems with that. Number one, hand counting takes a lot longer than machine-assisted tabulation. So if your concern is how long the results take to be finalized, hand counting is not going to help you there. Second, hand counting is also less accurate than machine-assisted tabulation. There have been scientific studies, real-world experiences that show that repetitive tasks like counting are something that human beings are just not well suited to do consistently and accurately. And so hand counting ballots, actually, you end up with more errors. It's less accurate than machine-assisted tabulation that can then be verified by audits or smaller hand counts to just confirm that the machine is working properly. So this push for hand counting really leads to slower and less accurate results and puts a huge strain on election administrators who already have their plates pretty full with tasks that they need to carry out after Election Day. Fortunately, in Georgia, just this week, we've had 3 decisions from 2 different judges in state court in Georgia blocking the enforcement of these new rules adopted by the state election board there, including a rule requiring the hand counting of every ballot at each precinct on election night, when election workers are already stretched very thin at the end of a long election season. Those 2 judges in these cases ruled that the state elections board exceeded its authority by requiring these hand counts because they're not required by Georgia state law. And also that it's just too late to be introducing changes like this into the election process just a few weeks out from Election Day, when, as of today, hundreds of thousands of voters in Georgia have already voted. And election workers have been preparing for months with trainings and getting everything set up. It's way too late to inject this kind of chaos and confusion by introducing new rules at this stage of the process.
Absolutely. And I think building on that question, can a state refuse to certify election results?
No. So one of the other rules that the state election board adopted had to do with the certification of election results by county officials. And some people in Georgia argued that this rule would have allowed counties to delay certification after conducting a reasonable inquiry if they were unsure about the results. But that's not what certification is. Certification is really just the last step in the long post-election process of counting and verifying every vote. What certification really represents is the symbolic end of the election process. It is the official declaration of the vote totals. And as Trevor mentioned, earlier, if there are legitimate concerns about the conduct of the election, the way that it was run, whether votes were tabulated accurately, there are other mechanisms and other processes that states have, things like recounts and audits and election contests and litigation. There's a whole slew of procedures that states can use to verify the election results and evaluate any challenges or concerns that candidates or voters have. And certification is not a part of that process. Elections have to end. There needs to be a formal conclusion to the election process, and that's what certification is. When an official chooses not to certify election results, what they're really doing is excluding an entire jurisdiction's votes from the final totals. They are refusing to count an entire county or an entire state or an entire precinct's votes, which is why state and federal law make certification a mandatory legal duty. We don't give election supervisors or boards of election the discretion to throw out an entire county's votes because they don't get to decide who wins an election. The voters do.
I would add to that, if I could, briefly, Manal, that the election official does not have the right to ignore what the voters have done. Once the process has concluded, the decision of whose electors are chosen is up to the voters. And for an official in a state to deny certification would be to take away electors that under state law a particular candidate is entitled to. And that's why this is purely an administrative decision, because otherwise you could have one person deciding that they know better or have a different preference than millions of voters. And that's not how the system works. A candidate is entitled to those electors once the process has concluded.
That's exactly right. And that's why after the 2020 and 2022 elections, when county officials in a couple of counties in places like Arizona and New Mexico refused or declined to certify the results of the elections in their counties, statewide officials and state courts immediately stepped in, and state courts in both of those states, Arizona and New Mexico, issued orders requiring those counties to certify the lawfully cast votes of the voters in their jurisdictions.
Wonderful. Thank you very much for that very, very important clarification. Let's turn a little bit to talk a bit more about the Federal Election Commission. So starting with Aaron, can you discuss how the FEC is addressing important issues affecting spending in this upcoming election?
Sure. Thanks for that question, Manal. So the Federal Election Commission is a 6-member, bipartisan, independent agency whose responsibility is to apply, interpret, and enforce the laws concerning the financing of campaigns for election at the federal level. And for many years, the FEC has developed a well-earned reputation for dysfunction as a result of the fact that those 6 commissioners, that 3 of which are from each of the 2 major parties, often would deadlock on the most important issues before the agency about how to interpret different questions of campaign finance law whether and how to enforce the law, whether to conduct investigations. And the consequence of that dysfunction over many years was a lack of clarity about what the law actually means, a regular routine failure to investigate alleged violations, even when the facts were clear and compelling, and ultimately no accountability when the law was violated. And the result of that was that we sort of had a de facto lawless environment where political actors could routinely violate the law, or certainly come quite close and stretch the line, with being assured that the FEC would not investigate or enforce the law or interpret it in a way that resulted in any accountability for them. And this was problematic for years, and something that folks who work in this area have been concerned about. But in the past few years, we've seen a concerning shift that's actually even more troubling than this deadlock dysfunction that we had grown accustomed to. And what we're seeing more recently is actually a precedent-setting majority of commissioners agreeing to affirmatively deregulate the law in a way that prioritizes the interest of donors and politicians over voters. And we've seen this play out in a number of different contexts. A couple of examples. So one, the FEC recently had to address whether outside groups who are allowed to raise and spend money independently from the candidates they support in unlimited amounts, whether they actually can coordinate with the candidates that they are supposedly spending and raising money independently to support. And according to 4 FEC commissioners, the answer is yes in certain circumstances. Another question they recently addressed concerned whether spending on electoral ads that criticize a federal candidate for the way in which they are seeking office counts as express electoral advocacy. According to 4 commissioners, the answer is no if those ads are run early enough before an election. And that has ramifications for the types of transparency and disclosure that are required for those ads. And so why does this matter? Why does a 4-commissioner majority vote matter? Or why is it different than the sort of deadlock dysfunction that we had grown so used to? And the reason it matters is because when 4 commissioners agree on a decision, it's not just a non-decision or a deadlock, but it can be a precedent establishing decision that can be binding on the FEC, on the political actors that have to follow federal campaign finance rules, the regulated, or in this case, unregulated community. And it can also have enforcement consequences outside the FEC, like in the criminal context, when the Department of Justice may get involved and have to interpret and apply campaign finance laws, and even the way the courts interpret the law. I think it's notable that one of the commissioners who consistently votes in this block of 4 commissioners was quoted in the press for stating that the deregulators are winning, which is kind of an odd brag for somebody whose job is, in fact, to be a federal regulator. But, to get back to your initial question, how is the FEC sort of carrying out its duty and affecting our elections? I think the answer is it's doing the exact opposite of what it's charged with doing. It's not regulating, but it is affirmatively and proudly deregulating. And it is not protecting voters. It is prioritizing the interests of donors and politicians.
Thank you for that. And building off of that, can you go into a little bit more depth about how this might change the way candidates and outside groups approach this election?
Yeah, absolutely. So, I mentioned one of the examples of how the FEC is interpreting the law lately was an example concerning what counts as coordination. And the reason we care about that is because in the Citizens United decision, now 15 years ago, the Supreme Court announced that corporations are people, and as people, they have the right to raise and spend unlimited amounts of money. And the court assumed and assured us that this would not be a problem, nothing to worry about, because that spending would be transparent and, importantly, independent from the candidates that are being supported. And so there would be no sort of planning between these outside people and entities raising unlimited amounts of money and the candidates they're supporting. And so no concerns about being beholden to them or quid pro quos or just like a general appearance of, things not being right. But the FEC keeps proving that the Supreme Court was wrong. And just a few months ago, the FEC issued an opinion where they said that these independent groups that can raise and spend unlimited amounts of money can coordinate with candidates on things like canvassing, where they're going door to door and talking to voters, even handing out literature that may expressly advocates for the candidates that they are supporting. And what does this mean for, regulated or what does this mean for the political actors and for voters? Well, here's what I did some research to see how the big law firms that advise politically active clients are advising their clients about what this means. And here's what some of them have said. The Federal Election Commission has issued an advisory opinion making it much easier for federal candidates to offload their paid canvassing programs onto state PACs, nonprofits, and super PACs. Here's another one. The FEC's recent advisory opinion is a blueprint for how some flame may jump the anti-coordination firewall, lighting the way for candidates to shift more costs to outside groups while aligning on messages and strategy. And be sure, and we know that candidates and their deep-pocketed donors have taken note. I think one of the most stark and recent examples is that Elon Musk, who has a super PAC called America PAC, which he has financed with 75 million of his own dollars. That PAC has spent $80 million on canvassing efforts for the Trump campaign, which means that the campaign has 80 million less that they need to spend on those activities and are free to spend that money on other things that they may wish to spend money on. Doesn't take much of a stretch of an imagination to sort of see why that's a problem, why we have a system in which a single individual can help a candidate to the tune of $75 million. It's quite clear that that's not sort of the representative democracy that certainly that our founders envisioned. And it certainly doesn't come close to resembling the independence that the Supreme Court promised us would be the case when they said that corporations could spend unlimited amounts to influence our elections.
Absolutely. Thank you very much for that, Erin. We'll pivot a little bit more to talk about what state laws changed and how those changes could lead to the disenfranchisement of some voters, including voters who voted in 2020 in key states that could affect the outcome of the presidential race. And why don't we start with Danielle?
Thank you, Manal. I'm so glad to be here today. Since 2020, election administration has kind of been at a peak in legislative activity. Every cycle now, we see the legislature kind of starting their session talking about other ways they're going to change their democratic system because there has been so much attention on our elections since 2020. And some of that has been quite positive, right? We've seen a number of states take positive steps forward to have a more inclusive democracy, restore voting rights for more people with convictions. But unfortunately, we have also seen a number of states take actions that are just going to make it harder for Americans to vote in 2024 in some states, in some circumstances. A lot of that energy has been on attacking mail voting. So especially immediately after the 2020 election, we saw some omnibus legislation in places like Florida and Georgia restricting vote by mail. How are they doing that? Kind of adding ID requirements to vote by mail, adding reasons why you might reject a vote by mail, adding additional requirements about having to kind of repeatedly ask for mail ballots for every election when previously the state had allowed kind of a permanent voting list. And also making it hard for people to help you with your mail ballot. So states across the country, Kansas, Missouri, Florida, Georgia, were restricting how people could kind of help you even apply for an absentee ballot. Can you send out absentee ballot applications to voters? Can you help them fill out that information, et cetera? Those are just a few examples that we've seen on attacks on vote by mail. We've also seen attacks on voter registration access. And that comes in kind of two different forms. One on making it harder to register to vote. Arizona has kind of been the poster child for that and trying to make it more difficult to register to vote. And then additional purges, legislation that would allow for kind of easier ways to purge people from the rolls based on inaccurate information. We also saw states recently leave programs like what we call ERIC, which was a system for kind of better, cleaner list maintenance in favor of their kind of own voter purge mechanisms. So those are all concerning developments that we've been following really closely. But CLC and its partners in the Democracy Coalition are not standing by while states are making it harder to vote. And we've scored important victories across the country that will safeguard the right to vote for Americans in 2024. A few examples of that. In Kansas and Missouri, those are two states where they tried to crack down on kind of simple assistance to voters, both at the voter registration stage, how you can engage in voter registration, and also at the absentee ballot application stage. Missouri tried to make it a felony, basically to help people in any way around absentee voting, including just encouraging people to vote absentee and to apply to vote absentee. We successfully knocked down those laws representing groups that engage in that activity, and the courts found that that violated the right to free speech and to free political activity. In Arizona, we have been at the forefront of fighting back against these new restrictions on voter registration. Some examples of what Arizona was trying to do. They were trying to say that they could reject your voter registration application purely because you didn't list your birthplace. We all know that where you were born doesn't decide whether or not you are an eligible voter in Arizona or anywhere in the United States. They were also trying to sidestep a 7-2 Supreme Court decision written by Justice Scalia that said that you cannot require documentary proof of citizenship for federal elections. And they were trying to sidestep that to say that their requirement for documentary proof of citizenship should apply to the presidential election, that people who had not met that requirement could not vote in the presidential election, could not vote by mail, despite that recent Supreme Court decision. And the district court, absolutely correctly, upheld that Supreme Court decision, knocked down a number of those voter registration restrictions, and most of those will not be in effect for this 2024 election. So unfortunately, we have seen some rollbacks on voting access, but we have also seen the courts step in to protect voters, and CLC has been kind of at the forefront of fighting back against those restrictions. And so I think the rules are set now. And so voters just need to know that the rules are set and that they need to follow those rules and make it to the finish line for Election Day in 3 weeks.
Absolutely. Thank you, Danielle. And congratulations on those wins. Taking it back to the FEC briefly, starting with Trevor, how do you feel about the direction the FEC has taken recently? And how does the FEC's current approach to decision-making differ from how the commission operated when you were the chair?
I think Aaron did a great job in explaining the problems we're facing with the FEC. The commission exists to enforce and interpret the federal election laws as passed by Congress and as revised in some cases by the courts. And if commissioners take it upon themselves to decide they don't like the laws, then the option they have is to argue that Congress should change them. When I was a commissioner, I can vividly recall votes on enforcement matters, meaning whether someone broke the law or not, where some of my fellow commissioners would say, I'm going to vote that they broke the law. I don't think the law should say what it says, but that's not my call. I agree the law says what it says. I agree they violated it. I hope the courts will find the law is unconstitutional, or we should recommend to Congress that Congress change the law. And every year the FEC makes recommendations to Congress for improvements in the law. But I think it is wrong for commissioners to decide on their own that they don't like the law, so they're not going to enforce it. That is the problem we've had now for a number of years. As Aaron pointed out, it was that we had 3 commissioners deciding that they didn't like the law and wouldn't enforce it, regardless of which party was injured, and the other 3 thought they should. So we had these deadlocks, and that's a problem because it meant without 4 votes, the law couldn't be enforced. Now we have a situation where one of the commissioners views herself as deregulatory and thinks that they're not going to enforce the law. As Aaron said, the issue with that is you now have 4 votes, which constitutes official commission action, that it's okay to coordinate with candidates, for instance. And that, I believe, violates the law itself. It also violates the fundamental court decisions in this area. Citizens United, which I disagreed with because it said corporate money could be spent in elections, was entirely predicated on the idea that it wouldn't be corrupting because none of that spending would be coordinated with candidates. It would be wholly independent. And the court's concept is, if you spend money independently, you don't talk to candidates about it, maybe you won't spend it the way they want you to spend it, it's not corrupting. Whereas if you coordinate with them and say, how do you want me to spend it? And then you go spend the $80 million, that is the equivalent of an $80 million contribution to their campaign. And most Americans understand that when a candidate gets $80 million, they're going to care what that person thinks, and they're going to want to stay in that person's good side. So to have the commission open up opportunities like that for coordination and bless it in the middle of a campaign and without any action by Congress is a real problem, I think.
Manal, can I just add one thing, which, I think one of the reasons why the FEC has been able to carry out this sort of deregulatory mission is that there are some court decisions that have essentially insulated FEC action from any judicial review when the FEC invokes something called prosecutorial discretion, which is to say effectively, well, we've determined that our resources aren't worth being spent on this particular issue. And for a number of years now, the FEC has been able to use that, what's intended to be, a sort of discrete basis for not carrying out its enforcement duties as a way to insulate any sort of analysis that it may have from any kind of judicial review. And that's made it really hard to seek any recourse in the courts. And so a very late breaking, exciting development is that the full DC circuit has agreed to reconsider that precedent just this week. And we're excited to be involved in that litigation to hopefully change that precedent, which would make it harder for the FEC to rely on sort of bad legal analysis and get away with it.
Yeah, thank you for both of those answers. Let's start with Danielle for this next question. There's a lot of interest in the possibility of local challenges to election procedures and law. What do you think might happen, and how should we make sense of that?
Thank you, Manal. I think one kind of bucket of concerns that folks have are around what we call mass challenges. What do I mean by mass challenges? That's probably pretty foreign to most of us. There is a process in most states that allows, an individual voter or resident to challenge another voters' eligibility. We can kind of wonder whether or not that's a good idea in general, but that process has largely been designed and thought of in the past as kind of very individualized. So if I, know, for example, that my neighbor has moved away and is no longer eligible to vote in my precinct, but is still planning to do so, or something like that, you can make an individualized challenge. Unfortunately, this process has been co-opted by those who are trying to kind of sow some chaos and distrust in our elections to engage in kind of mass challenging of voting based on kind of very shoddy database research. So you have individuals putting in hundreds or thousands of challenges to voters on the roll based on their kind of own research of whether or not they think that folks are eligible based on commercial databases or their own judgment about what kinds of residences are non-residential addresses and whatnot. This has a couple of harms. It really jams up election officials that have to kind of run through all of these challenges. And it poses real dangers to the individual voters who are challenged. They might not have an opportunity, an adequate opportunity to defend themselves. They could find themselves, kicked off the rolls if election officials are, too lenient in accepting these challenges. But again, CLC and others have really been vigilant, and I think election officials have been vigilant as well in pushing back against these mass challenges, rejecting challenges that are based on this kind of shoddy research, and we just have to make sure that that continues to be the case. There is something called the 90-day quiet period under federal law. And what that means is that in the 90 days before a federal election, we can't be engaging in any kind of systematic list maintenance where we're kicking off, large numbers of folks off the rolls, because that's really going to be subject to error. And then there's not going to be time for folks to fix those errors before the election day. So we're well within the quiet period. Normally, the quiet period is about election administrators. But if, individuals are putting in mass challenges and then election officials are accepting those mass challenges, that would fall under the same type of quiet period that normal systematic list maintenance would fall under as well. And a number of court cases have held that. And so we at CLC are being vigilant about making sure that if any election official were to kind of act on mass challenges and kick large numbers of folks off the rolls, that we have those federal law protections to come in and protect voters.
And thank goodness for that. What about emergency litigation? Are there issues that you think might require emergency litigation on or around Election Day?
Yes. Every election day, on and around election day, we see some amount of emergency litigation. I think that 2024 will be no exception. In fact, we might see a little bit more of it. So we're already in that phase. So CLC has 2 cases about that quiet period ongoing right now in Alabama and Virginia. And that's where 2 secretaries a Secretary of State in Alabama and the Board of Elections in Virginia are not respecting that quiet period and have tried to engage in various forms of list maintenance to either remove or inactivate voters during that 90 days. I'm very excited to be able to tell you that yesterday from the bench, a district court judge held that Alabama had violated the law and will ensure that all of the voters that had been inactivated on the rolls because of this unlawful program within the 90 days will be put back on the rolls and will be able to vote. And we have a hearing scheduled about the same issue in Virginia for next week. So we're already seeing some of that emergency litigation. We're likely to see on election day, every election day, we see some kind of hyper local litigation around, do we need to keep the polls open for a couple more hours because one polling location had to open late? That's all kind of ordinary course work that election protection does. And folks should expect to see some of that on election day. We have also seen, unfortunately, a number of late-breaking attacks on well-established voting rules by bad actors. So there's been a slew of lawsuits filed challenging the right to vote for a number of overseas and military voters. Those rules have been really well established. And so I'm confident that courts should just throw out all of those challenges as way too close to an election. And they're trying to disenfranchise American citizens and trying to change the rules on them when the ballots to overseas voters have already gone out across the country. So that's another form of emergency litigation. And then after the election, we'll probably also see various mostly bad faith attacks on abilities to cast mail ballots. And that's something where CLC plans to be active as well. But again, we saw a lot of litigation in 2020. All of it ended in a place where we were able to count all the votes.
Absolutely. That's the most important principle. Let's talk a little bit about that period right after the election. So in the post-election period, starting with Jonathan, can you tell me a little bit about what the dates and processes are for the states to submit electoral college votes and for Congress to process them? And have there been recent changes to the electoral college law that have been enacted?
Sure. Thanks, Manal. I think a lot of people probably forget or maybe never really fully understood that we don't directly elect the president and the vice president in the United States. That's why we have the Electoral College. When you go and you fill out your ballot and you fill in your choice for president and vice president, what you're really doing is voting for a slate of electors who will represent your state and cast their votes on behalf of the people of the state for those candidates in the Electoral College process. So every state sets its own post-election processes and deadlines for counting ballots, for conducting the canvass, which basically is just looking at all of the totals as tabulated from all of the precincts, adding them up, and making sure the math checks out and that all the votes have been counted, and then certifying those results. That's typically a bottom-up process. So it starts at the county or other local jurisdiction and works its way up to the state before we get to the Electoral College, which is a national process. This is the first presidential election that's being conducted using the procedures established by the Electoral Count Reform Act, which was adopted by Congress on a bipartisan basis in 2022. CLC strongly advocated for that law, which really modernizes the process of counting electoral votes. The previous law that governed this process, the Electoral Count Act, dated back to the 1870s. So it was time for a refresh. And among the things that the ECRA does is set a new federal deadline by which each state has to certify its presidential election results. This year, that deadline is December 11th. So every state has to finish their post-election process after Election Day and have a final certificate of ascertainment of the electors, which is the formal document that declares who the properly chosen electors are for each state, by December 11th. Then on December 17th, each state's electors meet in their respective states to formally cast their votes for president and vice president. That's usually, there's a lot of pomp and circumstance. They gather usually in the state capitol, they take a picture, they sign the certificate. It's a largely ceremonial process, but it's an important one because those are the formal votes that are cast on behalf of the American people for president and vice president. Then once that's done on January 6th, the newly elected Congress meets in a joint session to formally conclude that process, to count all of the electoral votes that have been submitted by each state and formally declare the winner of the president and vice presidential races.
Thank you for that. And pivoting a bit, we're going to go to Aaron. How should the government and tech companies be combating misinformation ahead of the election?
Thanks for that important question. So misinformation and disinformation is not a new phenomenon in elections or otherwise. The Senate Intelligence Committee published an extensive report documenting Russian efforts to interfere in the 2016 election through an extensive disinformation campaign carried out on social media platforms. What's new this election is that we're seeing the incorporation of artificial intelligence, which allows for a really effective and convincing effort to mislead voters about all kinds of information. So artificial intelligence, often called deep fakes, are deceptive audio or visual content that creates an image or a voice that sounds so convincing that people are led to believe that they're seeing things that didn't actually happen or hearing things that were not actually said. And you can imagine how this can be really problematic in elections, but a couple of recent examples really illustrate it. So in the lead up to the New Hampshire primary, voters in New Hampshire received robocalls from someone that sounded convincingly like President Biden, telling them not to vote in the New Hampshire primary because if they did, then they wouldn't be able to vote in the general election. This wasn't true, and it wasn't Biden saying it. And the person behind that actually faced criminal charges and potential penalties by the FCC. Another example that folks probably are familiar with was an image that was circulating broadly on social media that appeared to be Taylor Swift endorsing Donald Trump for president, something she never did. The image was doctored, but Trump himself shared the image and then purported to accept her endorsement. And what these examples show us is how AI can really interfere in the democratic process, either by or whether we're talking about making voters believe that someone's endorsing a candidate that they may really respect and or be inclined to follow, and sort of affecting the choices that they may make and how they cast their votes based on false information. And also can affect whether voters feel like they can trust the results of elections or know where to cast their votes because of misleading information that they're receiving as a result of AI. And because artificial intelligence is this new and evolving technology, the laws that we have in place really don't adequately fully address it. So we are seeing some efforts to close those loopholes and address the problem. The FEC recently issued an interpretive rule, which is far from sufficient, but certainly better than nothing. And what this rule does is clarify that existing regulations that make it illegal to misrepresent yourself as acting on behalf of a campaign or a candidate apply when artificial intelligence is used to do that. The Federal Communications Commission has also proposed regulations to require disclaimers, basically information in communications that contain AI or deceptive AI, to make clear that they in fact do use artificial intelligence. And these developments are important, but as I said, they're not enough. Congress is actually considering a number of pieces of legislation that would address artificial intelligence in elections in a more comprehensive way. We've also seen a number of states take steps to address it at the state level. And then I think lastly, you asked about tech companies. So certainly there's a role for tech companies themselves. They can address this through their own content regulation rules. I think the problem is that without laws in place to require that, tech companies are really free to adopt whatever rules they want or don't want. They're not accountable for enforcing or applying those rules. And also they're not necessarily consistent across platforms.
Thank you very much, Erin. Appreciate that. And speaking of, one of the many threats coming up and that we've been monitoring, Danielle, can you tell me a little bit about how we're preparing for the possibility of political violence and how concerned folks should be about that?
Thanks for the question, Manal. In a time of kind of heightened anxiety around our politics, I think it's fair that folks are concerned about political violence. We obviously saw political violence after the 2020 election on January 6th. And so it's an understandable concern. But I do want to try to put folks a little bit at ease and recognize how many protections are out there for voters, and how much work has gone into ensuring that voters will feel safe on election day. So perhaps it should go without saying, but both federal and state laws across the country make voter intimidation and various forms of political violence unlawful. And those who engage in it can face criminal consequences. And we have worked closely with election officials to make sure that they have up-to-date resources, not only on what the federal and state laws are on voter intimidation and political violence, but also on what tools they have in their toolbox to make sure that they're protecting voters. It's not just calling the authorities every time, but poll officials often have their own authority to tamp down on folks who are being disruptive at the polls. While there is certainly a right to observe elections from a appropriate distance, there is not a right to be disruptive at the polls, and election officials have the right to make sure that the polling locations are safe and accommodating places for the voters who are coming to vote. We have a legal fellow on our staff that focuses on voter intimidation issues specifically. And she gave a training internally to our office, for example, on making sure that we all understand what those rules are. We will be deployed in many states across the country on election protection efforts, armed with that information in being able to respond to any particular issues that come up at polling places. There's a really well-functioning election protection hotline where the moment these types of issues pop up, they can be reported and get to national legal resources almost immediately. We also have a Justice Department that is going to be deploying election monitors and watching out for any issues of voter intimidation on election day. I know that election officials have been thinking about protecting voters for years now, thinking about the security they need to have in place, the backup plans they need to have in place, de-escalation trainings. So this is something that a broad coalition of actors have thought about deeply. And there are laws in place to protect them, and then also the tools to deploy those laws in real time if needed. So it's not to discount the risk or suggest that voters' worries are unfounded, but I want also voters to know how much effort has gone into making sure that their voting experience is a pleasant and positive one. There was a lot of anxiety about this before both the 2016 and 2020 elections. And while there were isolated incidences, by and large, voters in both of those elections had very positive and welcoming experiences. And I would expect the same thing to be true this year.
Thank you. I certainly feel better hearing that. For our last question, we'll turn it over to Trevor. Since 2020, we've seen more disinformation about the security and accuracy of our elections. What should voters know going into November?
I think people need to understand that we have a dedicated group of local election officials, professionals, volunteers, people who spend a lot of time ensuring that votes are properly cast and accurately counted. Since the 2020 election, many election officials have gone an extra distance to ensure there is transparency, that voters know the process, that they are familiar with what happens, because people hadn't paid a lot of attention to the details before of the counting of ballots, the arrival of absentee ballots. On that front, it's important to understand that some states will process absentee returns, early voting returns, earlier than others. because in our 50-state system, they have different processes for doing it. So, for instance, in Pennsylvania and Wisconsin, those states won't do anything with ballots that arrive from voters ahead of Election Day until Election Day itself, when they'll start by comparing the signatures, verifying the outside envelopes before opening and beginning to count the votes. And what that means is on election night in many states, we're only going to have partial returns. So it's important as we're watching this to understand when it says somebody is at X percent of the vote counted, how many votes have been counted and what are those? Because again, in Pennsylvania and Wisconsin, those are likely to be in-day votes, those cast on the machines on election day as opposed to those cast in advance. And so pay attention to the description of that and whether there is expected to be a difference between who votes early and absentee versus who votes on election day. But we're going to hear, I suspect, because we have in the past, complaints that something is wrong with our election system. Remember that the election officials are going to tell us what's happening and why, and we need to have the patience to understand that this isn't all going to happen on one night. Some states are small enough or they process ballots early enough ahead of election when they come in that they will have a 95% return on election night. Others aren't going to have anything like that. So this is a multi-day process. And as we've discussed earlier, it is then subject to review, challenged by both candidates who have to present actual evidence if they claim there was something wrong with the tally. It's not sufficient to say, well, it changed overnight, because there's an answer to that, which is they were counting ballots overnight. But candidates will have a chance to lodge specific objections. They will be reviewed. All of us will see what those are. And at the end of the day, the election officials will then give us their final numbers.
Thank you, Trevor. And we're coming up to the end of the event now, so we'll turn to closing thoughts. Why don't we start with Danielle?
Thank you so much, Manal. I think my closing thoughts are, to everybody who's watching and kind of engaged in our elections, but maybe not as knowledgeable as some of us here on this panel, to not be too alarmed by the kind of fast and furious news that's going to come around election procedures in the next couple of weeks. I expect for there to be kind of new news almost daily at this point about a new lawsuit that was filed, a new action, a new kind of wrench that's been thrown into election plans. That is to be expected. But I think that we also have all the plans in place to deal with those. There are going to be many more lawsuits filed. But the courts have said that, these last minute lawsuits about well-settled election procedures should go nowhere. The rules are set and the rules are going to be the same now as they are going to be on election day. Jonathan told you just recently that, courts kicked out these new plans that the Georgia Election Board tried to put in place at the last minute. And I think similar things are going to keep happening. So there's going to be a new headline every day. I don't think that we need to chase every one of those headlines, but instead know that we have election processes that are in place that are meant to respond to those late-breaking developments in a way that still protects voters and protects our processes. So that's what I would say. Just get out there, vote yourself, make sure that everybody else is voting, and trust that the process itself is going to play out with folks like CLC waiting in the wings to address the problems.
Thanks, Danielle. Jonathan, anything to add?
Yeah, we've talked a lot today about potential litigation, about attempts to manipulate election processes or restrict access to the ballot. But I think it's important to remember, as Danielle alluded to, that judges and election administrators and county boards don't decide who wins elections. Voters do. And so it is up to voters to decide who is going to represent them, who is going to lead their government, whether that's at their municipal and county level or in the White House. So despite all of the political maneuvering and legal action surrounding this and basically every election these days, the power still lies with the voters to make that decision about who's going to represent them. And that's something that CLC tries to keep at the heart of our work. Danielle has mentioned a couple of times election protection, which is a national nonpartisan effort by election lawyers and volunteers to make sure that every voter in America has a meaningful opportunity to cast their ballot and have that ballot counted. CLC is a national partner for that election protection network. And if folks have questions about how, when, where to vote, or encounter trouble at the polling place or with an election office with their mail ballot, I would encourage folks to reach out to the Election Protection Network by calling 866-OUR-VOTE or using the 866-OUR-VOTE.org website to report any issues and get reliable information about how to vote this fall.
Thanks, Jonathan. Erin, did you have final thoughts?
Sure. Just really quickly, obviously, when we're talking about money in politics, a lot of that spending has already occurred. And some of the problems that I spent a lot of time talking about some problems, but what I would underscore is that we are actively working to address those problems to make our system better. And we're doing that on a number of fronts. We're doing it in the courts and we're doing it with policymakers, and we're active at the federal level, at the state and local level too. And so while most of what I talked about today was some of the problems in the system, you can visit CLC's website to learn more about all of the ways in which we're working really hard to address those problems and make it work more for voters.
Thank you. And Trevor, would you like to close things out for us today?
Yes, thanks, Manal, and thank you for leading us through this, I think, really interesting conversation. I'd just say, as Americans, we have an opportunity now to elect our new leaders, to cast votes, to know that those votes are going to be accurately counted, to know that at the end of the day, the people we choose will take office in a representative democracy. That's not something that much of the world can say. So it's a privilege to be able to vote and participate in that process. And I hope everyone listening knows where their polling place is, has made their plans for voting early or absentee, if that's what you're going to do, and that everyone understands that this is a process with many moving parts and an awful lot of dedicated people working in election offices around the country to ensure that at the end of the day, the voters' voices are heard and are acted upon.
Thank you so much to all of our speakers and for everyone who joined us today. If you have any additional questions or would like more information, I would encourage you to visit our website, campaignlegal.org, or you can email us at info@campaignlegalcenter.org. Thank you again and enjoy the rest of your day.